pleased to have as our guest today, Matt Minton from Marquette University. I would go into his whole title, but we'd be here for the next 30 minutes. He runs the sports law program at Marquette, past president of the SLA, and a good pal. Thanks for joining us, Matt.
Hey, my pleasure, Bobby.
So let's jump right into this. The way we usually like to start, and we will start today, is to talk a little bit about the sports law program at Marquette that you've been running and about your path to getting to where you are today.
Well, after graduating from law school, I practiced with a large Atlanta law firm. It's now known as Kilpatrick, Townsend, Stockton. My background was as an antitrust lawyer, and I did what I call non-technical intellectual property, mainly in the trademark, unfair competition, copyright area. I didn't even take a sports law course because I didn't think I would really be doing anything sports related, but did some sports related work. In fact, my first project as a young associate was convincing the trademark office that Old Timers Baseball Classic had acquired what's known as secondary meaning. People knew it referred to this game that was played in Atlanta in Old Fulton County Stadium. So I guess in some ways I was destined to be a sports lawyer. Then when I entered the academic world many years ago, the dean said, "What do you know about sports law? I have a petition from 90 students." I guess it was more like 70 demanding a course. That was at Texas College of Law, Houston. So I started teaching sports law, and after about 10 years, Marquette recruited me to come up here and be the director of the sports law program. I'm now executive director. Paul Anderson is the number one. I was number one for 16 years. Now I'm kind of the number two. We have worked together. So it was like one thing led to another, and I've been, very fortunate to do not only teach sports law, co-authored both a law school and undergraduate sports law text, and then have moved over and done some Olympic sport arbitration. I've been fortunate to be an arbitrator for Court of Arbitration for Sport, American Arbitration Association, and also JAM's sports arbitration program.
Well, that's a lot. So now that everybody knows your bona fides, let's jump into it with the opening question. What the heck is going on in college sports? I think, from the jumping off point, and if the students that are on, pay attention to us, because you should know something about antitrust, even if you're terrified of it. But we can start. I don't know if it's the place to start, but Alston case a couple years ago sort of said NC2A, you don't have an antitrust exemption, and that seemed to open up the floodgates.
Yeah, I think, even if we go back to the Supreme Court's 1984 Board of Regents decision, because up until that point in time, the NCAA is its member schools. They're the ones who make the rules. The association's a legally separate entity. And then the national office, they have a president and, of course, a legal staff and, roughly 500 employees. And they basically do what the members want them to do. And up until 1984, the association sold the broadcast rights to all its member schools' TV games. And the reason for that, the concern, was that the larger, more popular schools, the networks would only want to televise their games. And back then it was only 3 networks. That was even before Fox. And the interesting thing is so it was a group of what are now basically the autonomy conference schools exclusive of the Big Ten, and I guess what used to be the Pac, well, it was a Pac-8 back then. It was challenged by Oklahoma and Georgia because they said, hey, there's such restrictions on, the market wants to see those universities play more of their games. So it was member schools that successfully challenged the exclusive sale of football television rights at the association level as an antitrust violation. But there was a vigorous dissent by a couple of justices, including Justice Byron White, who was an outstanding college football player at the University of Colorado and was runner-up for the Heisman many years ago. And his concern that what would happen if antitrust law was applied to college sports, it would lead to kind of a dog-eat-dog world, where each school would be looking to further its own economic interest. So post Board of Regents, each conference started selling its own TV rights, with the exception of Notre Dame. They've always sold their own rights individually. And that's really what has happened. That's really key, because then what's driving the conference realignment is schools want to be part of a conference with the most lucrative college football media rights deals, because then you get a larger slice of the pie and you can use that to get the best coaches. And then that funds pretty much all of the other sports that are offered. So I go back to Board of Regents to that. There's kind of the start of it.
Yeah.
And then up to Alston. Alston says, well, if two or more conferences collectively agree on anything that has an reduces economic competition among themselves, for it could be television rights, student athlete compensation, a whole host of things, then section 1, which has the if you lose an antitrust suit, there can be injunctive relief granted. There's the possibility of treble damages, and then it's a fee shifting statute. So the losing defendants would have to pay the prevailing plaintiff's attorney's fees, and these cases are not inexpensive.
No, not at all. Well, we just, as all this is going on, and we've seen over the last couple of years, a couple of things, which has led to conference realignment. You started to see a few years ago where the SEC started to expand and bring in schools, and the Big Ten added a couple schools. Then in the last 2 years, my beloved Pac, fill in the blank, I was a Pac-8 athlete, Pac-12 seems to be now it's the Pac-2, and those two seem to have a lot of power. But you've had conference realignment and changes. And one of the questions that I've had, and I've thought about it, when we talk about the change in college sports, a lot of the money is made in 3 places: men's and women's basketball and football. But a lot of these universities have 19 to 30 varsity sports, and they rely on those 3 sports I've just mentioned to really fund the other sports. But now we're in a situation where, what does this realignment mean when you have SC and UCLA traveling to the Midwest and the East, Cal and Stanford now traveling all the way across country? What's the economic impact on all of these other varsity sports, and do they survive? I mean, I don't know the answer, but it raises a lot of questions. Obviously, we've seen, certainly in public education, public higher education, it used to be when dinosaurs ruled the earth and I went as a university student, the state provided a lot of money for higher education. That shifted, and unfortunately, so many schools have come to rely on these big media dollars to support not just athletics, but other things. Where does this all lead?
Well, that's the $64,000 question, although in today's terms, it's probably $64 million
Sure.
question. And yeah, it's one thing, because it's really what's driven the conference realignment is, wanting, to be in a conference where you get a huge share of football media rights things. And that does typically subsidize the other sports. It is only football, men's and women's basketball in general. There are certainly some exceptions. And I think the most recent report, there's only 10 schools nationwide that finished with, net revenue generating. They take the schools, the schools that generate the most revenues, there's some over 200,000, they come real close to spending that or above that. And so I hope it doesn't come to a model of where there's just football and enough women's sports to satisfy Title IX. And then all the other sports move to more of a club sport model. I would really hate to see that. There's, north of 500,000 NCAA athletes. It's just a relatively small number that play Division I FBS football and then Division I basketball. And, college sports, when, the association was founded back in 1905, 1906, it was on an amateur educational model. Clearly, men's and women's football, basketball has moved to a commercial educational model. And now there's a move to make it a commercial professional model. And I mean, the implications of that, could be many, many less opportunities for men and women to get at least part of their college education paid for and get their degree, because it is true that you can be a great college athlete, but very, very few make it in the pros. At least, you're not going to earn enough money to support yourself and family for a lifetime. So that degree is very, very important to get.
Yeah, and I also think it's interesting to note that, that touches upon NIL, and it's always been, I think, a lot of people have said, well, given the statistic that you just laid out, the small percentage of the student athlete that gets the opportunity to pursue a professional career, that during those 4 or 5, or in COVID, 6 years that you're in college, if you have the ability to make some money off your name, image, and likeness, that'd be great, But it seems that with no national standard, which we've talked about many times, it's difficult to avoid even the perception of pay to play. And then last week, you have Coach Harbaugh, I know your arch rival to the north, Coach Harbaugh coming and saying, if you really want to support diversity, equity, inclusion, then share the money with these players. That's a pretty big statement to come from a college coach at a major program at a major university.
Yeah, it certainly is. And to the extent that you start doing that, then that cross subsidization that we talked about, you might, if football is professionalized and college football players are paid, then what Title IX will say, well, there's got to be proportionally equivalent benefits and treatment for women athletes. And then schools would have to do that because they're required by law. And that pot of money then is that, okay, we don't have much left over. You'd have to see alumni or donor funded some of the other sports that don't pay for themselves. And I mean, that could theoretically happen. It could have a very adverse impact on Olympic sports, track and field, gymnastics. Women's volleyball is becoming very, very popular. That may well be a revenue generating sport there. But yeah, I mean, it could be very much a move away from what has traditionally been the amateur educational model of sports. That's be interesting to see, what is left of that model, 3, 5, 10 years down the road.
I know it's a question that has to be asked, because when you start talking about, we're on this continuum, do you fall from name, image, and likeness into being a salaried employee? And if you're a salaried employee in these sports, for example, and one of your conditions of employment is that in order to stay employed, you have to complete 12 units per semester of academics. And if you're getting a scholarship, that scholarship would now seem to be a taxable event.
Oh yeah, I mean, that is the thing, right now, let's say you go to Northwestern University. What is that, about roughly 75,000 in just
Something like that.
tuition? And then you add room and board, probably close to 100,000. Right now, it's a great benefit to the athletes that's and nationwide. You don't have to pay taxes on that. But you just wonder, what's driving a lot of this is two areas of federal law, antitrust and labor law right now. But I've always thought that federal tax law might be it's kind of looming in the background. And I think it's important to ask, would most college athletes be better or worse off if the IRS now says, okay, if college sports is really professional in nature, if you're employees, then they're going to say you're going to pay taxes on it. And then guess who else says that? State governments. And then look how aggressive some cities and municipalities have been. Philadelphia was, their view is if you're an NFL player and you play one of the games there, well, that's 1/17 of your income that is subject. And when you start adding all of that up, it's like, wow, I have to get what, 60,000 worth of NIL income to pay my taxes on it?
Right, to pay my taxes.
Yes, that's the so I'm not sure that going that route is, if we look at, what do we have? Just more than 500,000 NCAA student athletes. And then you got NAIA and all of the others on it. And that issue is just not looked at. The other thing that's interesting, and you being a media rights attorney, you did that sports media, is that once you're an employee, this idea that, well, I want to share the broadcast revenues from it. No, you don't, because then it's a work for hire. I mean, that's something that gets totally disregarded. I mean, unionized major league professional athletes have made that argument and courts have rejected it. They've said, no, you can't get, claim that you're getting, well, you get it through revenue sharing, but you can't claim that, your right of publicity is being violated by being incorporated into a broadcast of the game itself. It's
Well, you just look at, there's a case pending in the Northern District of California in Judge Wilkins' courtroom, because she seems to get all the cases, that they're arguing that all scholarship athletes in men's and women's basketball and football are entitled to a piece of the media rights deal from 2016 to 2021. I mean, think about that. Think about just, what do you do? And if they say, okay, well, everybody in that class is entitled to X thousands of dollars. If I'm the quarterback at, some power school and went on to an NFL career, I'm going to say, I don't want to be a part of that class. I'm going to sue on my own to get a piece of that money because I'm worth more than an equal share that everybody else got. So I think we're already treading on sharing the media rights deal. And obviously, if there's success in a case like that, which seems to me a pretty far stretch, given that I can tell you from a media perspective, there was nothing put into the valuation of the rights payment that had to do with name, image, and like of the athletes. So to backtrack and say, well, it could have been, would have been, that's a very slippery slope in a damages calculation.
I agree entirely, because up until that, really up until cases like Alston and O'Bannon, courts had pretty much held that, the NCAA amateurism rules were per se lawful. And, there was like a reliance interest up until that point. And what they're trying to do is go back 4 years, because that's the 4-year statute of limitations under the Sherman Act. And that does make damages calculations very difficult. And, I think it's 90% of all the revenues that the NCAA takes in. And that comes largely from, again, it's over 90% of the revenues they put on championships in all the sports except Division I FBS football. That is a product of the conference commissioners. They put that on. That is a separate. It comes from the men's and women's basketball tournament on that. And then those revenues, over 90%, get paid out to schools to use to provide various student services and things like that. So again, if the plaintiffs win that suit, you got treble damages and then the attorney's fees, that pot that goes out to schools that, benefits athletes in sports other than men's and women's basketball and football gets further reduced.
Yeah. Well, look, so hot off the press news item. For those of you that are SLA members, you get that benefit of the Sports Business Journal subscription, keeps you up to date on lots of things, particularly something that we talked about, Matt and I talked about before we got on the air, is this recent case that was filed by Oregon State and Washington State, basically enjoining the Pac-12 board from meeting, I think, reading the tea leaves, claiming that once the 10 other schools decided to leave the conference, they have no vote and they can't take care of business anymore. Where does that lead us?
Yeah, that's really interesting because, and again, I haven't looked at the complaint. I haven't seen the court's order. What I know is based on Sports Business Journal, which does a great job of really covering the waterfront. But as I understand the case, is the Pac-12 bylaws say that once you announce that you're leaving, and everyone has announced that except for Oregon State and Washington State, you lose your seat on the board of directors. And the only two standing are like, well, we are effectively a board of two, and they're of course on the same page. What they want is they, want to rebuild the Pac-12 conference if they can do it, have the rights to the name, which is very valuable. That's been around for so long, and it'd be interesting to say, well, does that mean you get all the existing media rights on it?
Matt? I think we have a technical difficulty with Professor Mitten has frozen on us. Let me see if I can. Well, we hate to lose him, but let me see if I can get him back in. But we'll keep talking about this. Does anybody in the audience? I have one question here, which I really want to direct to Matt. But if anybody has any other questions or comments, you can put them in the chat or the Q&A. Hopefully we get Matt back in here soon. I think he's going to try to log back in. But I think we're in an interesting time in college sports. Obviously, we had Power 5 conferences. I mean, is we down to the Power 3 conferences, maybe the Power 4 conferences? Because obviously the Pac-12 is gone. And what that does is obviously the whole FBS football championship is based in large part upon rules based upon the 5 conferences. After this season, they're going to either have to change those. Oh, you're back. But you're muted.
All right, how's that?
All right, good. Glad to have you back. So we were talking about the role that with only 2 schools sort of taking control of a conference, and you were talking about media rights deals, but part of that also is, I don't know what the liabilities are of the Pac-12 network, but what do you really want those assets? Or would you rather just sell off what they have and take some cash? It's an interesting position they're taking. I don't know really. I'm only reading what I read in the funny papers, but I think it makes for a really interesting analysis on what happens. And if the bylaws say that, what else do the bylaws say? Are there a minimum number of teams that have to be present? Can you have a 2-person conference? Has it even looked at that? I mean, there's some deep questions here, and I know we'll be hearing a lot more about it in the next couple of days.
Yeah, and I don't think anyone anticipated that, 10 of the 12 members would leave. I mean, it was probably, maybe 1 or 2, but it's like those are really the only 2 left standing.
Well, look, SC and UCLA left, which really hampered the Pac-12 network from getting much carriage and getting much traction. And, as we saw, not getting really any money. And that was a problem. And there's a whole other discussion about that whole launch of that network and what it meant. But SC and UCLA had a lot of cachet, and I believe the Big Ten went after them to get the market here, not only because it gets you the LA market, but because there's a lot of Big Ten alumni in California. And that helps with your carriage and a lot of other reasons. So that's what happened there. And they left. And then Colorado, the doormat of the conference, who now seems to be pretty good with Coach Prime, they say we're leaving. And then 3 more schools leave, and then 2 more schools leave, and then you're left with Oregon State and Washington State. It's been crazy. But I want to get to a couple of quick questions in our chat. One of them is something that we talked about earlier, you and I, and that is, question is from Earl Wilson: as super conferences continue to rise, would the total number of conference become illusory for high school recruits?
No, I think, there's going to be the same number of schools that are out there. I don't think there's going to be any fewer schools at the Division I FBS level, but it'll be interesting to see if there'll be a split off. You can roughly half that number. What was it, 64 or so that were in the Power 5 conferences? That'll be whether they kind of go their own way, more of a professional model there. One good thing, which I would like to see, is the so-called Group of 5 conferences, if they would join together and have a national championship. So it's going to be a 12-team championship starting next year, Division I FBS, and that's going to create some opportunities for, other than the traditional, you got 3 times as many spots. But I don't know if there's a split within that, and you could have different rules. I mean, one of the things under the new NCAA Constitution, each division has greater autonomy to make its own rules. So within Division I, we got Division I FBS, but within that, there's kind of the haves and the have-nots, the Autonomy 5, Power 5, the other Group of 5, then FCS, and then the non-Division I schools without football programs like Marquette. So who knows what'll happen?
And I have another question, the shortest question ever from our friend Steve Ross. Is it so clear that Title IX requires a university that has a professional team to provide equivalent opportunities to women? Good question.
Well, I think the argument to make that it isn't is Title IX applies to all aspects. Athletic departments don't receive federal funds, but yet athletic departments are covered under that. And I think that's going to be a tough argument to say, well, our football team, that is totally separate and apart from our athletic department. If you look at the legislative history of Title IX, there was the argument that some made, football is separate from everything else. And I wouldn't expect to see courts all that receptive to that argument.
This is such a great topic, college sports, just what's happening. And, it's interesting when you look back on the history, you say the start of the association in 1905, and then all of the action that it took really in the 1920s and 30s to avoid the seeping professionalism into college football in particular, the fact that the NCAA created that phrase, the student athlete, at the time to sort of justify its existence. And I think our friend Ken Shropshire's book, The Miseducation of the Student Athlete, needs a new version in this new world now, because it's become so different with, and even now high school athletes signing 6-figure NIL deals. So here's my question. Do we even know what amateurism is anymore?
Well, it's certainly evolved over time. And, what we can say now is student athletes, at least in certain sports, those who are, very popular, are, what do they call them? Influencers, have media platforms. now they're able to get their cut of it from third parties, not from the schools. You still, schools aren't able to provide cash payments for playing services. So clearly there's been an evolution over time. And why is there such commercialism in college sports? Because they're so popular, particularly men's and women's basketball and football. And the question is, okay, how do we divide the pie? And you've got equitable issues. Most of the revenues are generated by athletes of color, and they do subsidize, largely pay very large 7 and 8 figure salaries to white coaches. Sports played largely by white athletes. So, I mean, it's a cauldron. If you look at it with college sports, there's just legal issues, economic, political, all kinds of things. The other thing is, is Congress going to get involved here in enacting a net federal NIL rights legislation, or maybe go a little bit broader? It's really hard to predict at this point what is going to happen. But it makes for some very interesting discussion, and why, if you're part of the call, if you're not a member of the SLA, why you should be a member, and why it's so much fun to teach sports law courses and look at the job opportunities that have created. We have legalized gambling now, and then there's got to be monitoring. Now that there's NIL rights, well, of course, athletes can be represented on the business and legal side, everything. And, you can be over in Germany. I sat next to someone at the Packers game from Germany, and they were over here and said, we had to see an NFL game. Why? Well, we've gone to the game in Frankfurt when it's played. I mean, so it's, geez, I mean, you couldn't ask for a better time to be interested in legal issues in sports.
Well, and I think we're at a time all over, but certainly in college sports. And honestly, I think we can't avoid talking about high school sports at the same time, because the changes are, there as well. And then you have a whole other layer of, in high school, of, oh, I'm a minor and I'm signing a deal, and all of those rules you learn first year of law school about contract law and minors contracts, et cetera, et cetera. So I think it's a really exciting space. I think there's a lot more going on in college sports. And, where's that tipping point between professionalism and amateurism? And we don't have the answers yet. There's lots of legal action going on. And as you said, what better place to find it than the Sports Lawyers Association? And that's what we're trying to be a leader in. That's part of our mission statement. And I think we're working hard to do it, and having the ability to call on someone like you to spend little time talking with us only helps us meet those objectives of being a place to talk about sports and sports law and where we're going, and maybe not always having the answers, but certainly saying, here's another question for you to consider, because that's what we do. And it's a really exciting time.
Yeah, and it is, and it's important to get new voices and new perspectives also. Some of us have been doing it for a long time, but it's equally important those it's their first time on this. Bobby, you have to promise me that you have Professor Steve Ross as a guest so that I can ask him some questions. But
Guaranteed.
No, he always has some great thoughts.
Yeah. Well, Matt, all I can say is I'll give you a big O. Good luck this season.
Thank you.
And thanks for taking the time to join us. Everybody, don't forget, go to sport. If you're not already a member, go to sportslaw.org and become a member of the Sports Lawyers Association. And this November, on November 2nd, we'll be having our second mid-year symposium. And we'll be talking about AI, which is another huge topic that crosses all kinds of legal disciplines. And we'll have 4 panels for you on Thursday, November 2nd. So information coming out about that shortly. Look forward to seeing you all soon. And Matt, thanks again. Really appreciate you taking the time to be with us.
Yeah, thanks, Bobby. And I look forward to that seminar. AI is something I know very little about, and you got a great lineup of speakers. So I'm going to be the student for that symposium seminar.
Me too. All right, Matt, take care. Thanks again.